This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about problems faced by hurricane victims in Louisiana who seem to be deprived of adequate counsel, and why McClenny, Moseley and Associates is not responsible for all case failures in the state of Louisiana. The court concludes there is no excuse for failure to promptly serve a governmental agency. And I can't understand why it took so long to serve. In Jimmie Legros versus Weston Property and Casualty Insurance Company, the United States District Court for the Western District of Louisiana, on April 3, 2025, found that after Weston became insolvent and the suit was amended to change the defendant to the Louisiana Guaranty Association, LIGA, the service on LIGA was late. LIGA moved to dismiss, and the magistrate judge concluded that the evidence, the law, and the arguments of the parties recommended that the motion to dismiss be granted. Plaintiff filed the present action on August 25, 2022 against Weston Property and Casualty after suffering property damage during Hurricane Laura. The case was stayed from October 21, 2022 to March 30, 2023 due to the suspension and termination of plaintiff's prior counsel. On November 30, 2023, plaintiff's current counsel enrolled, and on February 5, 2024, plaintiff filed a motion to substitute party requesting that LIGA be substituted as defendant for Weston Property and Casualty, which was granted on May 22, 2024. LIGA moved to dismiss because they were not properly served until 134 days after their substitution in violation of Federal Rule of Civil Procedure 4M. Plaintiff conceded that LIGA was not served within 90 days as required by Rule 4M, but requested the court to deny LIGA's motion as plaintiff can establish good cause of the delayed service, as this case was due to plaintiff's prior counsel. Federal Rule of Civil Procedure 4M provides that, quote, if a defendant is not served within 90 days after the complaint is filed, the court on motion or on its own after notice of the plaintiff must dismiss the action without prejudice against the defendant or order that service be made within a specific time. The district court has broad discretion in determining whether to dismiss an action for insufficient service. It is undisputed that LIGA was not served within the required 90 days once it was substituted as defendant. To establish a good cause, a litigant must demonstrate at least as much as would be required to show excusable neglect, as to which simple inadvertence or mistake of counsel or ignorance of the rules generally does not suffice. Plaintiff contended he can establish good cause for delayed service. Specifically, per the plaintiff, this matter was previously handled by McClenny, Moseley and Associates, or MMA, and upon their dismissal by the various courts in multiple jurisdictions, clients were left without representation for extended periods of time. According to plaintiff, the delay in effective service was due to the extraordinary circumstances resulting from MMA having to withdraw from the handling of thousands of files. While the court was sympathetic to the problems faced by the parties, who were left without representation following MMA's suspension and the need for additional time to organize, sort, and process the multitude of cases, it does not excuse plaintiff's delay in service or failure to properly request an extension. LIGA was substituted as defendant well after MMA was removed from this case and after plaintiff had secured new counsel. It was not until May 22, 2024 that LIGA was substituted as defendant for Weston Property and Casualty Insurance Company after their insolvency in August of 2022. For the next 4 months, the record shows that no action was taken to advance the matter. No request for an extension of time to effect service was made. Rather, LIGA was served on October 3, 2024, 134 days after it was substituted as a defendant. The court concluded that plaintiff failed to establish the requisite good cause to exercise failure to effect service in a timely manner. Plaintiff's counsel entered their appearance in this matter almost a full year before effecting service, and accordingly the court recommended that LIGA's motion to dismiss be granted. In my opinion, LIGA is a governmental agency easy to serve with a complaint. For reasons known only to counsel, it took almost twice the time required by federal rules. Took 134 days to serve the defendant. New counsel tried to blame old counsel, MMA, for the delay, even though they had successfully moved to change the name of the defendant to LIGA from Weston. They did nothing to effect the service for 134 days when it could have been done immediately. The violation of the rules required dismissal. For once, the fault did not belong to MMA, who is now in bankruptcy. The plaintiff, Jimmie Legros, is not without a remedy, since the court has already found the dismissal was due to the failure to act of his current counsel. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll gain notice of every blog posting, usually 5, sometimes 6 a week, and also access to the more than 5,050 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.